Contract Act serves as the primary legal framework governing contracts, delineating the conditions under which parties can enter into binding agreements. A critical aspect of this framework is the recognition that not all individuals possess the capacity to enter into a contract, particularly vulnerable stakeholders such as minors, the elderly, and those with mental disabilities.
Let's begin with the concept of coercion in Malaysian contract law. Coercion is defined under Section 50 of Contract Act 1950 as the committing or threatening to commit any act forbidden by the Penal Code or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever with the intention of causing any person to enter into an agreement. Now, the key elements of coercion. First, it involves prohibited acts such as those forbidden under Penal Code, including assault, criminal intimidation, or wrongful confinement. Second, there's the unlawful detention of property. Third, the act must be intentional. And finally, the act or threat must harm the victim's ability to freely consent. For example, threatening bodily harm. Similarly, threatening to expose private information or withholding property to compel agreement also constitutes coercion. Even threats are made to the third party like a family member fall under this category. What happens if the coercion is proven? Contracts influenced by coercion are avoidable under Contract Section 19 of the Contracts Act. The victim can either affirm the contract or rescind it entirely. The law ensures fairness through restitution, preventing any party from gaining unjust benefits. There's few cases that can be discussed, which is Muthaiya versus Karapan Chetty at 1887. The court voided a contract signed under imprisonment threats. Similarly, in K. Sarmal versus Velayappa Chetty, 1954, the court emphasized that any form of lawful pressure undermines consent. Moving on to the contractual capacity in Malaysian law, this refers to the legal ability of individuals to enter into enforceable agreements as outlined in the Contracts Act 1950. The ones who are legally capable of entering the contract is adults that is defined as 18 and above. Have the capacity. Secondly, the individual must have sound mind, meaning they should understand the terms and conditions that is agreed in this agreement. Now, the exclusions of this would be minors, for instance, generally cannot enter into the contracts unless the agreement involves necessities like food, shelter, or education, or something beneficial to the minor. Similarly, individuals of unsound mind, those are unable to comprehend what's happening in this agreement. When this criteria does not meet, contracts are generally void. However, exceptions are made during the landmark case Mohori Baibi versus Dharmodas Ghosh, 1903, is often cited, where the minor's contract was ruled void because of incapacity.
Hi everyone, my name is Arvind Sarvanakumar, and today I'm going to present about the protection for vulnerable parties against coercion. To protect people from exploitation, threats, and undue influence, Malaysia has put in place a number of safeguards against the vulnerable parties. There are some ways, such as implementing cooling off period. It means legally mandated waiting times. It is to prevent hasty decisions made under emotional stress and pressure. In the cooling off period, both parties will reconsider their decisions and seek counseling and legal advice. These periods can vary depending on the jurisdiction and the type of legal matters. And then the second way is conducting legal remedies undue influence. It means when a person is coerced into making a decision, example, signing a contract, later they can claim undue influence. If proven, courts can notify the contract and effectively restoring the individuals to their original position. This protection ensures that agreements are made voluntarily and without improper pressure. And the third way is making education and awareness campaign, raising awareness about the sign of cohesion and the available protection can empower individuals to recognize and report a cohesive behavior. Educational programs can be conducted in schools, workplace, communities, and among the people to inform the society their rights and resources available for them. Last but not least, by conducting a support services. Some various organizations are provide free low-cost legal advices or counseling advocacy for the vulnerable individuals. These activities are crucial to helping people to understand their rights, access necessary resources.
Assalamualaikum, my name is Naafika Hisham and I will explain on legal remedies that are available under coercion and duress. As you can see here, there are 4 of remedies that are available. First, a coerced party may simply notify the wrongdoer that he wants to terminate the contract because he was coerced or in duress. Secondly, if the wrongdoer don't want to terminate the contract which he resists and apply for specific performance, the coerced party may just not do anything and decline the specific performance. Thirdly, decision of contract. The coerced party may rescind the contract in 2 ways. First, this is actually similar to the first remedy, where the coerced party can just communicate to the wrongdoer about contract termination. Secondly, the coerced party may bring to the court under Section 34 of the Specific Relief Act 1950, where it emphasizes that the court may void a contract if the contract entered by the plaintiff is voidable. This means that if the court find the contract was entered forcefully by the plaintiff, the contract thereby void. Once the agreement becomes void, both parties have no obligation towards that contract and any benefit received must be restored. This is what happened in Shinambi Development, Sendira Berhad and Tai Kim Chu and others, where the defendant were asked to return the additional 4,000 ringgit to the plaintiff as the contract was entered forcefully by the plaintiff and the contract was void. The coerced party may also repudiate the entire contract to avoid unfairness and future problems, as explained by the judge in Segar Oil Palm Estate Sendirian Berhad and Teh Tobok. Lastly, the remedy of restitution. The objective of this remedy is to put both parties into the original position before they making any contract. According to Section 65, 66 and 73 of the Contract Act 1950, both parties must make refund, restore or compensate each other if they have give or receive any benefits. This is to provide equity which not just the wrongdoer must do but also the plaintiff, as stated in Section 30 of the Specific Relief Act 1950. In Bergama Development Sendirian Berhad and Act Development Sendirian Berhad and another, the defendant was ordered to compensate 2.2 million ringgit to the plaintiff as the agreement of lower price between them was void. In Transnational Express Sendirian Berhad and others and Tan Chong Industrial Equipment Sendirian Berhad, the defendant was also ordered by the court to pay refund the plaintiff as much as 16 million ringgit as the contract between them was void because the plaintiff forcefully entered the contract.
Alright, the Contract Act of 1950 governs contractual capacity and coercion in Malaysia but faces challenges in protecting vulnerable parties. Where minor contracts are void, under the case of Mohori Baibi versus Darmodas Ghost, with no exception for beneficial agreement like in the UK's Minors Contract Acts of 1987. And proven maintenance capacity, under the case of Tan Hee Juan and Teh Boon Kuat, is complex and it lacks provision for temporary incapacity as seen in the case in Australia. And also, coercion under Section 15 excludes economic duress recognized in the UK under the case of Sibot and the Subotra and is limited in cross-border contexts, where we have where statutory protection like the Consumer Protection Act of 1999 are less robust than the EU or South Africa. Courts take a conservative approach where they underuse the doctrines like unconscionability or when the case of Central Inland Water Transport and Brohonat Ganguly. And lastly, we have a dual legal system that complicates the integration of Islamic principles, while socio-economic barriers and limited legal aids further disadvantage marginalized groups. Malaysia's approach to contractual capacity and coercion, as what is outlined in the Contract of 1950, provides a solid legal foundation, but it also faces challenges in protecting vulnerable parties, where in Section 11 it sets a clear requirement for contractual capacity, such as being sound of mind, of legal age, and not disqualified of law. However, it actually lacks for beneficial contract involving minors, unlike what we have in UK's Minors Contract Act from 1987, or the more progressive approach of Indian courts like in the case of Suraj Narayan versus Suku Akhir. Meanwhile, in terms of mental incapacity, the focus is on the soundness at the time of contract formation, as seen in the case of Tan Hee Hwan and Tin Bukiat. But there are no provision for temporary incapacity, like Australia Contract Review Act of 1980 or the USA mechanism to prevent unjust enrichment. Meanwhile, in the case in coercion, defined under Section 15, is limited to act prohibited by the Penal Code and excludes economic duress, which jurisdiction like the UK and Canada has recognized as legitimate ground for invalidating contracts. Consumers protection under the Consumers Protection Act of 1999 are foundational, but less comprehensive than the EU Consumer Right Directive, and Malaysian courts seldom apply doctrines like unconscionability, as in the case of Central Island Inland Water Transport and Brohonat Gangehi. While Malaysia's legal framework incorporates multicultural and Sharia influence, reforms are needed to integrate equitable principles and address socio-economic vulnerabilities. For the examples like New Zealand Failed Trade in 1986. As when we can strengthen these areas, it is essential to ensure justice and fairness for all parties in contractual dealings.
In conclusion, the relationship between contractual capacity and coercion in the Malaysian legal system proves the critical need for robust and radical approaches to protect these vulnerable parties. Coercion, as an important factor into whether the contractual agreements made are valid, highlights the importance of consent in contractual relationships, while consent is obtained through threats or undue influence that undermines the fundamental premise of a fair contract.